Matt Day here with Parsons, Graham and Day. Want to take a second to talk about when you should modify your custody or visitation orders. All right. There's not necessarily a set rule, but there's some good guideposts. All right. Whenever there's been a significant change, it's a good time. If you and the opposing party come to an agreement on a new schedule, that's a good time. Sometimes when you're going to enter a new order, someone will have to file a motion to put those issues before the court. That doesn't mean that you'll have to go in and fight or litigate. You can just agree to things, and one of you can file a motion and then put those things in writing that the court can then sign. But if you're a parent who has been receiving alternating weekends and suddenly now you're receiving week on, week off, you want to file to get that put in as the order, because at some point the opposing party could try and go back and say, no, we're just going to do the alternating weekends because that's what's in the order. All right. So anytime you have a significant change, right, you want to go ahead and get that put in place, and it doesn't have to be a battle. Let's assume for a second that one of the parties was originally granted sole legal custody, and now suddenly there's an agreement for joint legal custody. You want to file that motion. It doesn't have to be litigious. It doesn't have to be horrible. You can just do what you guys have agreed to as reasonable and rational human beings. Okay? But you want to try and do those things quick, fast, and in a hurry when you've had those significant changes. The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons, Graham and Day and anyone watching this video.